relationship as means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or family members living together as joint family. Now, what is to be seen is particularly here, if you see it, the act makes it very clear that when two persons are related to each other by consanguinity, consanguinity means by blood. So, in such a relationship where the female is a victim from another relative of hers who is related to her by blood. Husband and wife are not related by blood, they are related by marriage. So that means this relationship does not protect only women, as we were talking about living relationship, but also sisters, also mothers. Fine, because the law says that who had at any point of time lived together in a shared household, they were living under the same roof when they are related by consanguinity, by marriage. So even a wife can claim the remedies that are there under Domestic Violence Act. So when a wife has to claim any kind of remedy, then it is for her to decide whether she wants to, what kind of remedy she is looking forward to. If she wanting to claim maintenance, she can file under HMA, HAMA, under CRPC, under even Domestic Violence Act. So this act also gives a right to the wife as such, or through a relationship in the nature of marriage. Now, this is very, very important. We'll get into this. I'll explain what that does mean. But after that, adoption or a family members living together as a joint family. So even if two persons like cousins, if they are living under the same roof and they belong to joint family, and there is a female who is a victim in that joint family, so she can also claim maintenance, she can also claim her rights under Domestic Violence Act. So though the general perception is that a woman who had been in live-in relationship can only claim under Domestic Violence Act, but that is not the case. It is any female who is in a shared household, who is in a family and is related to the other person by blood, by marriage, by adoption, or is a member of joint family, can claim the rights under Domestic Violence Act. Since what the perception has so grown that it is limited to the women in living relationship, because they are the ones who primarily claim, they have, this is the only way, this is the only act under which they can claim their right. So they are generally the majority among the sisters, among mothers who claim their right. That is why it is so understood that this is only for them, but it is not so. It is also for the protection of mothers, sisters, or any female in a joint family, or even those who are related by adoption. Now, it also has used the term or through a relationship in the nature of marriage. It first uses consanguinity, that is by blood relationship, then it says by marriage, and then says through a relationship in the nature of marriage. So it has to be a relationship which is in the nature of marriage. That means two persons are related to each other in such a way that they could be considered to be husband and wife, because they have lived together as husband and wife for many years. Together, they have been together. It is just the formality of marriage that has not taken place. So they both are capable of getting married to each other. That is the first criteria. That is why they have not used it simply live in relationship. What they have used is that the relationship was in the nature of marriage, as if they were married couple. And they could be considered to be married couple when, only when it is it that they both are capable of marrying each other. There is no embargo between them to get married. It is just that they have not entered into the formalities of marriage. That means both of them have attained the age of maturity. Both of them do not come within prohibited relationship. And there is no other embargo which stops them from getting married. It is just their decision that they have not gone through the formalities. That is what is the meaning of through a relationship in the nature of marriage. That is why it is so understood when it is said that it is to be in the relationship of marriage. That means they are living as husband and wife, and there is no embargo in the sense the both of them have attained the age of majority. Either of the party must not have any spouse living at the time of getting into such a relationship, because then only this relationship could be considered to be in the nature of marriage. Suppose if the husband has already a wife and then he starts living with someone, then obviously this with whomsoever he starts living with, that is not in the nature of marriage, because he cannot validly marry this other person with whom he has been living. That is why the law, when it had to define it, when it had to bring every such woman into its domain, it made it very clear that it will not respect those women, it will not give protection to those women where the spouse, the male partner was already married and then the male partner gets into relationship. So it only protects such a woman whose male spouse is still unmarried or was divorced. Then only she will get protection under the act. But if the male partner was already married, irrespective of whether he had hidden the fact or she knew the fact or she was not knowing about this fact, still she cannot claim maintenance, she cannot claim the remedies that are there under Domestic Violence Act.
Excuse me, ma'am.
Yes, yes.
Ma'am, can this act also include mental trauma endured by the female partner?
Yes, let us see. It has given a very wide definition of domestic violence. It has given a very wide definition. When a woman has suffered domestic violence, so the act defines what is domestic violence. Let us see this. How has the act defined what is domestic violence? And your question would be answered from that. Fine. It says, for the purpose of this act, any act, omission, or commission or conduct of the respondent shall constitute a domestic violence in case it harms or injuries or endangers the health, safety, life, limb, well being, whether mental or physical, or of the aggrieved person, or tends to do so and includes causing physical abuse, sexual abuse, verbal abuse, emotional abuse, economic abuse, or harassment. So, if you could see here, it includes every kind of abuse: physical abuse, sexual abuse, verbal abuse, emotional abuse, economic abuse, or harasses or injures or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security, or has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in clause A or clause B. So it is not only when the respondent is directly affecting the aggrieved party, even if the respondent is affecting or is showing domestic violence towards certain person who is related to the aggrieved person, then also that will amount to domestic violence. Otherwise injures or causes harm, whether physical or mental, to the aggrieved person. The reliefs that are there, the the Domestic Violence Act also has a provision which says that the Women Under Domestic Violence Act, the DAT party, has the right to have shared household. That means she can claim also for the household, the house where she wants to stay. The respondent would be liable to provide her the household, the place of residence. While disposing of the application under subsection 1 of section 12, the magistrate may direct the respondent to pay monetary relief to meet the expenses incurred and the losses suffered by the aggrieved person and any child of the aggrieved person such as a result of domestic violence. And such relief may include, but not limited to, the loss of earnings, the medical expenses, the loss caused to destruction, damage, and removal of any property from the control of the aggrieved person. So that means there is a provision even for providing monetary relief to the aggrieved person under the act. The maintenance for the aggrieved person as well as the children, if any, including any order under or in addition to an order of maintenance under section 125 of CRPC or any other law for the time being enforced. That means apart from giving monetary relief, just hold on. Yes, apart from giving monetary relief to meet the expenses incurred and suffers expenses incurred and the losses suffered by the person. It also has clause for providing maintenance, even if the aggrieved party has filed for maintenance under section 125 of CRPC. So under section 125 of CRPC, we saw that it is the wife who can file for maintenance. It is the mother who can file for maintenance. So even under Domestic Violence Act, a wife can file for maintenance. And if she has filed for maintenance under 125, she can also file for maintenance under section 120 under Domestic Violence Act. A mother can file under section 125 of CRPC. She can also file under Domestic Violence Act. Then the question would come up that if a petition has been filed under CRPC as well as under Domestic Violence Act, where is she going to get relief? Is she going to get relief at both the places, or she is going to get relief at only one place? Wherever she has got relief initially, suppose she has got relief under Domestic Violence Act, a maintenance order has been passed in her favor and the court has granted maintenance there. So now, since she has already got maintenance there, and when a petition under Domestic Violence Act is finalized and the amount of maintenance is to be found out, that what is to be the maintenance that needs to be granted, the amount that she has already got under CRPC would be considered accordingly. She will be granted or she will not be granted, but her right would be respected, that she has a right, that would be accepted, that she has a right under Domestic Violence Act. But at the same time, she would, since the amount that is sufficient for her maintenance has already been granted under CRPC, no further amount needs to be granted under Domestic Violence Act. So there is no embargo on the wife to file maintenance for maintenance at only one place. She can file for maintenance under all the four places if she is a Hindu. If she is a Muslim, definitely she can file under Domestic Violence Act as well as under CRPC. Or for that matter, if she is a non-Hindu, then only under Domestic Violence Act as well as under CRPC. But if she is a Hindu, then she has avenues to file under all the four acts. That is HME, HAME, the CRPC as well as Domestic Violence Act. The monetary relief granted under this section shall be adequate, fair, and reasonable, and consistent with the standard of living to which the aggrieved person is accustomed to. So, here, what should be, I have already said that this is the parameter that is taken into consideration, that what should be the amount that needs to be given as a way of maintenance to the aggrieved person will be the with the standard of living that she was accustomed to. So finally, what do we see is that under Hindu law, both husband and wife, Hindu law, particularly under HMA, both under section 24, 24 and 25, 24 which deals with pendant light maintenance, 25 which deals with permanent maintenance, entitles both husband and wife to claim pendant light and permanent maintenance. Under HAMA, there's no provision for husband, it is only the wife who could claim maintenance. Under CRPC, again, no protection for the husband, it is only and only for the wife. Even under Domestic Violence Act, it is not only for the wife but also for sister, it is also for mother, as well as those who had been in such a relationship which is in the nature of marriage. We have these cases. Amarkanta, these four cases have already been circulated. I thought to do these cases today, but the time is already up. We'll again meet tomorrow. I hope everyone agrees to that. We can have class tomorrow also.
Yes,
Fine.
ma'am.
Yes,
At the
ma'am.
same time, at the same time, ma'am.
Cases tomorrow. This is how we are going to complete a syllabus. Otherwise, I have to run through the entire syllabus, and that will be of no use then if you do not understand the
Hmm.
subject. Fine. So please read these cases
Ma'am, at
again.
the same time,
Hmm. Yeah, tell me, Archana. Archana, you have raised your hand. Go ahead, Archana. Archana, am I audible to you?
Yes, ma'am.
Yeah, what happened?
Ma'am, I have one question. Harman this side, not
Yeah.
Archana. So my question is that suppose ancestral house is in the name of husband and wife, and now wife and
Oh,
husband
oh, 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 no, 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 no. Yeah, the question itself is wrong, Herman. Ancestral house cannot be both husband
transferred.
and wife. Please understand. It is either it would be of the husband's family or it would be the wife's family. Because the moment you say ancestral, that means it has come from the forefathers. Fine.
And
So it cannot be.
what about the house that isn't ancestral? So can it be in the name of husband and wife?
It now if a property has been purchased by both husband and wife, obviously the property is of husband and wife. But if it is husband has earned his own income and has purchased a property only in his name, it is his property. If wife has earned and purchased the property in her name, that is her property. Is that clear?
Okay, ma'am.
Both of them do not have rights in each other's property till both of them are alive. When one dies, the other then will have right in the other's property, not where, during the lifetime. Fine. I'll take your questions. There are two questions that have been written in the message. Won't the wife be able to claim maintenance under HMA and MA itself even at the time of... She still, mm, Arkodeep Datta, she has a right to claim whatever petition is filed under HMA or HAMA. She has the right, even in the time of judicial separation. She can file for maintenance, both interim as well as pendant right maintenance.
Okay, ma'am. Ma'am, in addition to that question, I had a question regarding Section 25 of the Hindu Marriage Act.
Yeah.
Like it has been said that such payments may be, yeah, may be scored a second, yeah, in scored if necessary by a charge on the immovable property of the respondent. So
Yes.
you have explained it itself that if defendant tries to sell off the
Yes.
property, the person who buys the property is
Will be
obligated to pay the maintenance.
yes, yes, yes. You cannot
But
kill the right of the wife. Yes.
But then the third person who has already who has already paid to the husband the sum of money has to
Yes.
compensate the wife.
No, because the husband is liable to maintain his wife just to get away with that duty of his. He has sold off, willed, gifted that property to someone else. So that way he cannot kill his wife's right. Please understand.
So
Fine.
what?
When the person is purchasing the property, he is getting into all the liabilities that are attached to that property. Fine.
Okay.
That
Okay.
is
So
why
degree would be passed against the third party or the husband and its
it's a
husband
charge that has
side.
been created on the property. So whosoever
Okay.
the property passes, right? Now, if
Uh,
the property has gone to the third party, now he further sells it to someone fourth party. The charge will go with that property. So now that fourth party will
okay.
be responsible. Fine.
Okay. Okay.
Yes, Archana, you
So
have raised your hand.
ma'am, I was asking na कि you have said the nature of marriage in
Yes.
uh, F section F domestic relationship or
Yes.
through a relationship in the nature of marriage.
Right.
So the onus of proving that marriage lies on the wife because husband could easily denies from that kind of relationship.
Yes.
So
She
wife
has
will
to
have
prove.
to prove.
Yes.
And what will be the parameters for that?
That what are the parameters? First, that she has to prove that it was in the nature of marriage, both of them were capable to marry. She was not already married, first thing.
Okay.
Second, both of them are majors. Third, they are not within the prohibited relationship. Fine.
Okay, ma'am.
Those are the general parameters. Yes,
Okay,
Nishant, you
ma'am.
have raised your
Thank you
hand.
so much.
मैम जैसे आपने कहा था कि वो जो लॉ कमीशन ने रिकमेंड किया है कि सेक्शन 4 एक और मतलब सॉरी सब
हाँ,
सेक्शन एक और डालने के लिए कि जॉइंट फैमिली के ऊपर अगर पर्सन हस्बैंड मतलब मेंटली इलनेस है कुछ तो वो होगा। तो अगर सपोज दैट मेंटली इल है
हम्म,
और जॉइंट फैमिली नहीं है और डिवोर्स फाइल किया जाता है और उसके साथ एलिमनी या मेंटेनेंस को भी लगाया जाता है, तो कौन पे करेगा मैम उस केस में?
ना ये तो बहुत ही पेक्यूलियर केस हो गया ना, जब उसके पास कोई प्रॉपर्टी भी नहीं है और वो भी मेंटली है, तो उसके लिए कुछ नहीं किया जा सकता है। फाइन, उसके लिए कुछ भी नहीं किया जा सकता है। ठीक है।
थैंक यू मैम। ठीक है।
यस अर्चना, यू हैव रेज्ड योर हैंड।
And what if, ma'am, that a mentally unstable husband, uh, suppose hypothetically, ki they have ancestral properties, and that unstable man used to sold the properties without getting the knowledge of the rest of the family.
नहीं,
So,
अर्चना अर्चना, इस पर अभी हम इसलिए नहीं बात करेंगे क्योंकि आपको उस प्रॉपर्टी की डीलिंग कैसे हो सकती है आपको पता नहीं है।
okay,
राइट,
okay,
उसमें बहुत सारे नुएंसेस हैं, बहुत सारे पेच हैं उसके अंदर। फाइन,
hmm,
ठीक है ना। इसलिए अभी हम उसको, अगर हम उसको समझाने लगेंगे तो अभी उसको समझाने में ही 1 महीना लगता है।
okay, ma'am,
फाइन, तो दैट्स नॉट इजी।
okay,
फाइन, यू विल स्टडी इन फैमिली लॉ टू।
okay. Thank you
यस
so much.
सिद्धार्थ, यस। लेकिन टू आंसर योर क्वेश्चन अर्चना, whosoever are the right holders in the ancestral property, on his own he cannot take any decision of selling of that property. Fine,
Okay, ma'am.
ठीक है।
Thank you so much.
सिद्धार्थ, yes सिद्धार्थ।
Yeah, ma'am, any comment on this case of Badshah versus Urmila Badshah?
अभी
That's a
अभी
very, I thought
we
that's a very interesting case.
we will definitely be doing. That is why that is a part of a course manual, that even when the woman, when the husband was already married and he remarried, keeping his second wife in dark, how has the we'll just appreciate how the approach of the court in still giving her maintenance, and not on the ground that she is the second wife, her marriage is not valid, not on the ground, but on the social consideration that the purpose of section 125 was to protect the needy and those who actually were in such a situation that needed maintenance. So that is on the pretext the court, the Supreme Court has granted, even when she was the second wife, when her marriage was still not valid, then also the court had granted a maintenance. That is one of the exceptional cases. This is why it is a part of your course manual. Let us see how the court has tried to approach that, has tried to come to that conclusion by taking different considerations and protecting the right of such women.
Thank you, ma'am.
Yes, anyone, any question? There is a question here. Some business in the course of the, oh, no, let me, this is a good big question. If the wife had given up a job and to take care of the home and a husband, and the husband in turn built some business in the course of their marriage and registered any property earned in his name, upon divorce, will the wife still get any get maintenance? Does she not have the right to the property acquired during the course of marriage? Because considering she gave up a job and the husband grew the business on the back of the wife. There, who is this? Let me see. Who is this one? Who is Shweta Khanna? That's a very good question, Shweta. For your information, let me tell you that there is no concept of matrimonial property in India. Matrimonial property simply means that whatever property which is acquired by both husband and wife after marriage will remain the joint property of both husband and wife. Fine. So whosoever contributes that accumulation of that property, as your question goes, that it is the wife who was in job and then to take care of her husband's family, she left her job, and not only husband's family but her children, his parents, she left her job, and then she facilitated her husband to acquire, to accumulate more and more wealth, and he, with those wealth, he built up his property in his name. Now, there was no 1 rupee contribution that was given by the wife. The entire property was purchased by husband's wealth. But what is to be seen is that she is the one who facilitated the husband to be completely mentally free from his family affairs so that he could concentrate on his work, on his profession or his occupation, and grow his business. In case of matrimonial property, what happens is that even if there is no contribution of any party, the husband or the wife, but has facilitated that marriage, then in that case, whatever property is acquired, it becomes the property of both husband and wife. We do not have this concept of matrimonial property in India. So, whatever is acquired by the wife after marriage or husband after the marriage, it remains to be their individual property. And this duty of the wife, where she has, or this part of the wife where she has contributed immensely to the family by leaving a job, taking his parents' care, the children's care, is not appreciated in India. In sense of monetary value, so she do not get any right. Even when she has to be granted maintenance, then it has to be seen how much is the property of the husband, and she'll be only given in terms of value of the property, not a share in the property. And the only reason is that we do not have the concept of matrimonial property rights in India. Is that clear, Sneha? Shweta? Is Shweta there? Yes, Sneha, you have raised your hand.
Yes, ma'am. My question was, how does maintenance differ in different acts, like DVA, HMA, HAMA, HMA,
No,
CRPC?
there is no difference as such. It all depends upon where one feels comfortable with and what are the rights that are associated with it. If there is certain embargo, if I file under HAMA, I have to see that I do not fall in the embargoes that are there under the statute. Is that clear? So if I file under Domestic Violence Act, I have to, and if I see that filing under Domestic Violence Act, going to get much more advantages, that I'll be getting a right in the sharehold property, I'll be getting maintenance, I'll be getting other facilities, other advantages, then I'll file under Domestic Violence Act. It has to be seen where one fits in best, right? One doesn't come within the embargo that is there under different acts. That is why otherwise your right would be defeated.
Okay, ma'am. So can I file for divorce under HMA and then go for maintenance in whatever act I like?
Yes.
Okay, ma'am. Thank you.
Archana, your hand. You have raised your hand, Archana.
No, ma'am, I haven't.
Siddharth, your hand is still raised. Siddharth Mishra, you have a question?
My question
Are you
has
there,
already
Siddharth?
answered.
Oh, it's already done. So let us meet tomorrow. Is this time 8 o'clock convenient to every one of you?
Yes, ma'am.
Yes, ma'am.
Or you want some other time?
मैम एक्चुअली कल
Ma'am,
तो क्लास होगी मतलब 6:35 के बाद
कल
का
क्लास
क्लास
है?
यस मैम
कल
ज्यूरिस्ट
सैटरडे कल क्लास है?
यस मैम
yes,
अच्छा,
ma'am.
मेरी क्लास है।
मैम संडे को रखिए।
ओके, तो फिर बताएं किस समय आपको
मैम संडे सुटेबल
संडे?
Ma'am, you're welcome.
Can we have class in the morning tomorrow?
यस मैम
Yes, ma'am.
Your
Yes,
class
ma'am. Morning week suitable.
कितने बजे? क्या कह रहे हैं?
10
मैम
to
कल
12.
जो क्लास है वो 5:40 तक है, आप 8 बजे आराम से रख सकते हैं।
ये तो आपके सेक्शन में ना, दूसरे सेक्शन में कितने बजे तक क्लास है? The other section?
मैम 6:35 के बाद तक होगी आई गेस 7 to 7:30 मे बी
Okay. And your class, both the section classes start from 2 o'clock?
Morning 10 a.m.
10 बजे से क्लास शुरू हो जाती है आपकी, हिमांशु? हिमांशु? इससे पहले हम लोगों ने डिसाइड किया था कि जिस दिन क्लास होगी उस दिन हम लोग 9 o'clock ले सकते हैं क्लास, 9 to 10.
Yes, ma'am. 9 to 10. Okay.
यस मैम
So
Yes, ma'am.
we can have
Yes,
class from 9 to 10. Is that okay to
Yes, ma'am.
everyone? Fine.
Yes, ma'am.
Yes, ma'am.
ठीक है. So tomorrow
Okay.
9 to 10. Okay.
Ma'am,
Okay.
ma'am, I would ma'am, I would request you to ask the CR to make the group so that if when next time when you're handling stuff, he can give permission for the others to enter the classroom, enter the room.
Acha, that can be done. But there are
Oh,
two
the
CRs.
human support.
क्या कह रहे हैं आप?
Actually,
तो
ma'am,
आशीष,
he's asking to me, to make me as a co-host,
okay. No problem, I'll do it. They will
so that I
students.
can let them
But
in.
let the students to be a little more disciplined, come on time. Just
Okay, ma'am.
join on time and within 5-10 minutes, not more than that. That can be handled. Fine.
Okay.
Yes,
Okay.
ma'am.
Thank you,
No problem.
everybody.
Okay, ma'am.
Thank you so
Tomorrow.
much, ma'am.
Thank you.
Okay.
बाय एवरीवन। हटा तो दे, माइक बंद नहीं है मेरा। अबे ओए चुप हो, प्याज टमाटर मत कर। मम्मी भूख लग रही है।
चलो
भाई मेरे घर में खाना बहुत लेट बन रहा है आज। हेलो, कोई भी नहीं है क्या? अतुल, अतुल भाई नमस्ते। अतुल दम है तो अनम्यूट कर।
अतुल भाई प्लीज कर दो यार।
रहने दे, दोस्त है मेरा। अतुल
कौन है दोस्त है?
ये रहा ना
दोस्त है।
मोहम्मद भाई नमस्ते। पापा जी गाली दे रहे हैं मेरे, हमें भी सुना दे भाई, सुना दे।